Ms. Bank.
I'm sorry.
Now I'm trying to talk to Ms. Banks, the court.
আমার মনে হয় আপনি আমার ইন্টারপ্রেট।
I am.
This is case number 22-185480. This is New Center Spinal Rehabilitation Center versus City of Detroit. Your appearance regarding this pretrial matter, please.
Good morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of defendant, City of Detroit.
Thank you, Madam Counsel. Anybody here for New Grace? I have received a stipulation, the whole stipulation order to dismiss this matter. And Counsel, that's your understanding as to how this matter will proceed today. Is that correct?
That is correct, Judge.
All right, so I have signed the order, and I will make sure that that order gets out right away.
Thank you very much. Have a good day, Judge.
Thank you. This is case number 21-172-820. This is HS Financial Group versus Tamisha Jones. The matter is before the court on an application, a subpoena regarding efforts to collect on a judgment that was previously entered in this matter. That judgment was entered, it seems, in this matter on, put a date here. I don't see the entry date right offhand. Your appearance at this time, counsel? We have counsel for HS Financial Group. Mr. Dobbins, are you here? What do you call that matter? The court now calls case number 22-184-845. This is Evoke ION LLC, also known as Evokes LLC versus Maya Grimes. The matter is before the court, set on today's date for a pretrial conference of record. Sure, before that, the court previously issued a scheduling order regarding this matter and set for discovery to complete today. All right, your appearance for Evokes.
Good morning, Your Honor. This is Sam Morris. My bar number is P76766. We also have a motion for summary disposition that was filed November the 2nd and is set on for hearing today.
Thank you, Counsel. And good morning to you. Do I have Maya Grimes on the Zoom? If you're here, say something at this time.
It's Mia Grimes. Good morning.
Thank you, Ms. Grimes. Good morning to you as well. There is, in fact, I'm in receipt of the motion for summary disposition that's been filed in this matter together with an affidavit wherein the plaintiff is seeking that the court would determine that there is a basis for entry of the judgment at this point where they allege that there's not really an issue that is in dispute based upon the contractual provisions existing between the parties. Have you seen that motion?
Have I seen that motion?
Yes, ma'am.
No, I have not. I have not received anything.
All right, so it looks like this is, the court received it on the 4th of November. And looks like the information attached to this says that it was sent to you. And they're using the address of Mark Twain Street.
I don't reside on Mark Twain Street, sir. I live on 17694 Shaftesbury Drive Avenue.
Oh, I got it. Okay, Counsel, I'm seeing a couple of things. One is I'm seeing where at the time that there was a petition to adjourn this matter, that the address on the document for Ms. Grimes is on Avon Street I'm also seeing that on a notice that went from the court, there's an address on Mark Twain Street. So ma'am, did you receive the notice from the court to be here today, or you just went by the documents? What happened?
I received the document from, I guess, back in September, when this was issued, September 22nd. I received it. That was forwarded to me. I have not received anything past then.
Were you living
Because
at the
I now have my own place on.
Stop. Were you living at the Mark Twain address when the?
I have never resided on Mark Twain.
I tell you, you may be able to cut off wherever you like to cut off, other than when you come to court. If I'm asking you a question or saying something to you now, you have to be quiet until I ask you to respond to my question. It's very, very simple. That's very simple. That's not a thing of arrogance or anything else. The system that we work with here makes that even more important. All right. So my simple question to you at this point is, were you residing at the Mark Twain address on the 22nd of September? And if you hit *6, you can speak back to me now. All right, let me go on to counsel here. Counsel, it seems that the Mr. Morris, it seems that the defendant indicates in this matter she no longer resides at either of the addresses that the court has for her, and she's indicated that for that reason she did not receive your motion, sir. So you didn't use an address other than the Avon or the Mark Twain address. Is that correct, sir?
Correct, Your Honor. I served at the address that was on record with the court, the Mark Twain Street address.
Yeah.
If I
based upon this Grimes statement, that address would not be a correct address for us. So we're going to update that now. Ms. Grimes, what I'm going to need you to do, I'm going to need you to use your chat device and chat your email address to the court and to Mr. Morris. Not your email address, your new home address, so that a copy of this motion can be sent to you. You know how to use the chat on your device, ma'am? Okay, you need to hit *6 on your device so you can talk to me because I muted you. So go ahead and hit *6 on your device. That'll get you off of mute. You know how to come off of mute? Ms. Grimes? You know how to get your device off of mute? Just hit *6, man.
Can you hear me now?
Yeah, I got you now. All right.
Okay.
So we're gonna renotice this and send it out to your new address. But what I need you to do is, if you know how to do it, go into your chat and chat it to myself as well as Mr. Morris, so that this motion can be sent to your address. You have an opportunity to respond to it before the court makes a ruling. You understand?
I understand.
Are you able to use the chat device, ma'am?
Yes.
Okay. All right. So go ahead and put it in the chat. I'm going to set a new date, and I'm going to give you that date in just a moment. Mr. Morris?
Your Honor, before we proceed, Ms. Grimes did file a response last week. It is a homemade promissory note acknowledging her obligation in the amount of $10,000 and purporting to transfer the obligation to the United States Department of Treasury.
Okay, Mr. Morris, when you turned your head to the side, your voice became cluttered or clouded or whatever. So tell me what you were saying again, if you will, sir.
I apologize, Your Honor. Is this better?
That's better.
Thank you, Your Honor. Your Honor, last week we received a response from Ms. Grimes or a filing that she submitted to the court. It is a homemade promissory note acknowledging the obligation in the amount of $10,000, but purporting to transfer this obligation to the United States Department of Treasury. So, Your Honor, in the interest of economy and the court's time, I think there is, based on the response filed by Ms. Grimes, I think there's a basis today to enter the judgment, and whether or not Ms. Grimes can transfer her obligation to the Department of Treasury is maybe a matter for a different day in a different court. But I think that in and of itself is sufficient grounds for entry of judgment today.
Well, you're raising the issue of transferability of an indebtedness or whatever. Ms. Grimes, are you admitting today that you have an indebtedness here?
That was my offer. If they're going to uphold the contract, which again was did not have any.
Let me stop you again on my specific question to you, okay? My specific question to you is, are you saying today that you have an indebtedness that exists in regard to e-votes?
That was my offer, yes.
Okay, well, yeah, there's nothing to dispute there. It doesn't sound like you have a dispute. So if you're not disputing this, then the plaintiff would in fact be entitled to a judgment on the claim that they brought. You understand that, Ms. Grimes?
I understand that, and that was my offer in order to pay.
All right. Well, that's a little different. All right. Well, if there is not a genuine material issue of dispute, and it does not seem that there is one, then the plaintiff would be entitled to judgment as a matter of law regarding this matter. And the parties, if there is some claim of assignability, then that's an issue that is secondary to the underlying claim in this case. So I'll grant the motion as an uncontested matter, and I'll sign the judgment on the claim that is before the court. And then the parties, to the extent that there is some approach that can be used to transfer the debt to someone else, that's between the parties to, that's a secondary issue here. The primary issue is the underlying case here. So counsel, you may submit your judgment where the court finds that there's a genuine issue of material fact, and there's no significant dispute in this matter. The judgment is entitled as a matter of the law. Counsel, you can email that to Carmen.Banks. First name Carmen, CARMEN, Banks. Banks is the last name. That's at 36 District Court, 36th 36 District Court.org. And I'll make sure once it's signed up, Ms. Grimes, we'll mail a copy to you as well. Right,
so Your Honor, just to confirm, I have Carmen.Banks at 36th districtcourt.org.
That's correct.
Thank you, Your Honor.
All right, I wish the two of you well. Happy holidays to you.
Thank you, Your Honor. Same to you.
The court now calls case number 22184-871, Michigan CRNA staffing versus City of Detroit. The matters before the court set on for the pretrial conference date. Scheduling order was previously issued regarding this matter. Your appearance for Michigan CRNA, please.
Good morning, Your Honor. I'm Moira Gidebe Gross on behalf of the plaintiff.
Your P number, if you will, Madam Counsel.
P number is 73882, Your Honor.
Madam Reporter, are you able to hear Ms. Gross well enough?
Are you saying, did I get a P number, Judge?
Yeah, you got her name and P number, did you?
Yes, I got it.
It sounds kind of low to me, but I want to make sure that you got it.
Yeah. Oh, I see what you're saying. It is kind of low, but I did hear it and she has her name up there, so.
All right, perfect. For the City of Detroit, your appearance at this time, please.
Yes, Philip Hiltner, P77913 for defendant, and good morning, Your Honor.
Good morning to you, Mr. Hiltner, to both of you. All right, so you had some opportunity for discovery regarding this matter. What's the status of things now? Somebody give me an update, if you will.
Yes, Your Honor. We have exchanged discovery. I've responded to plaintiffs, but we're still waiting for plaintiff's response. It's a couple weeks overdue, I think, at this point. So I guess that's where we are. We've had some settlement discussions. We're not extremely far apart, but I think getting those responses to my discovery request would be helpful.
All right, gotcha. Ms. Groves, you got some discovery stuff that's yet to be completed, is that correct?
Yes, Your Honor. We have the Michigan CRNA and the anesthesia group, which is the same. One is the nurse and one is the anesthesiologist. And that information was previously communicated to defense counsel. It's the same medical record because it's the same procedure. So he's got the information as well. and we can forward that documentation that we already did before to him, so he would have that information. And as he stated, we're close to, our numbers are close, and it's about maybe less than $50 apart at this point in time, but that's what we have, Your Honor.
Well, I would pull the difference out of my pocket, but then I'd have to do that about 10,000 cases, so I'm not gonna start that. All right, so what if I brought this back in late December? You think I can go all the way to the 22nd?
That would work, Your Honor.
So let's bring it back in. I'll take a look at it. I'm going to go ahead and set it for review, given the fact that you seem to have achieved some traction with this. So I'll set it for 12/22, and I'll set that at 9:45 a.m. 12/22 at 9:45 a.m. So pretrial review. The court finds good cause for the adjournment of the pretrial on today's date for the reasons that's set forth on this record. All right, all of that's to the two of you, and you'll get a notice in this regard as well.
Thank you, Your Honor.
Thank you, Your
Enjoy the
Honor.
rest of your day.
Judge, good morning.
Yeah, good morning, sir. Can't come to you just yet.
Judge, can I take another matter on the front of Judge Johnson? They just text me to join to Judge on the front of Judge Johnson for a matter. I'm the interpreter for.
Are you in another courtroom?
Yes, Judge, and now 36 District Court telling me.
I'll be up there to deal with that as soon as I'm done with this courtroom. That judge is away, and I'll be there to deal with it. I'll be there to deal with it as soon as I deal with this guy. All right, so I'll see you shortly.
So do you want to take care of the other case?
Yes, when I get to that courtroom.
Okay.
All right, this is case number 22-186825. This is LBNB Funding LLC versus Thomas Gale. The matter is before the court, set on for a pretrial conference. Also, a motion for summary disposition is pending before the court. All right, your appearance for LBNB Funding, please. For LBNB Funding, please. All right, do I have Gail Thomas on the Zoom? Once again, I'm looking for LBNB Funding LLC versus Gail Thomas.
Gail Thomas is their judge at the bottom.
Okay, we'll come back to that matter momentarily. All right, this is case number 22-243098. This is Community Business Consulting versus Johnson Robinson. The matter is before the court on the filing of an appeal from a determination by a magistrate in this matter. Do I have Community Business Consulting on the zone at this time?
We're here, Your Honor.
All right, what is your name?
My name is Paris Boyce.
Last name is Boyce, is that correct, sir?
That is correct, Your Honor.
All right, thank you. I'm also looking for Jonte Robinson. Are you on the Zoom?
Yes, Jonte Robinson is here.
All right, thank you, Mr. Robinson. Just one moment, sir. All right, and I see that there is a motion for consolidation regarding other matters that have been presented to this court. It looks like that request for consolidation relates to Lambda Greenhouse under the suffix 100 and Malaysia Barry under the suffix 101.
Yeah, I could probably clarify the consolidation, Your Honor, if you allow me to speak.
Yeah, just a moment, sir. Yeah, you have a whole list of Daryl Watts, Juwan Boyd, Maya Greenhouse, and Malaysia Berry. All right, go ahead and tell me what's going on here, sir.
Okay, what it is on the same day that we adjudicated Mr. Johnson Robinson's small claims case, there were 4 other default judgments that were entered. Now, I don't believe that there's any dispute in the judgment. The only problem is that the amounts didn't include the process serving mileage fee for all 5 of them. So for like Mr. Robinson's, it's a mere $15.23 that was not added. And for the other 4, which we were asking to consolidate so that we wouldn't have to have 5 separate hearings on this matter. And I'm not sure if you have the process servings updated. The process servings showing the amounts with the mileage fee missing. But it's just a request. The appeal is for a request just to have those mileage fee amounts added on to the judgments for each 5.
You already have a judgment on the cases. We're talking about Mr. Robinson in a moment. The other case, you said you have a judgment by default in those matters.
Yeah, the other 4 are judgments by defaults. Now those were we asked the small claims judge Kleperic, we filed a motion to ask him to correct it, and just give the mileage, 4 separate motions. But then when he denied the 4 motions, that's when we appealed to you, Your Honor.
All right. So in the judgments in those 4 cases, you got what you asked for, except for you say mileage, right?
That's correct, Your Honor.
All right, so tell me about the mileage. Who did the service?
They were all done by Horace Taylor. He gave the $26, the service fee, that was included as part of all the judgment, just the mileage fee was not.
Yeah, and I'm not going to include the mileage fee either. So whatever you charge is whatever you charge. All right, so those will stay the same. All right, now as it relates to the matter that's in front of me, it looks like that you appealed this or that Mr. Robinson appealed this.
We appealed it, Your Honor.
I'm sorry, Mr. Robinson.
I was gonna say no, I don't appeal it, but I wanted to see if I can at least have the pay date extended. I got hit with the IRS garnishment, so I'm just trying to get maybe 30 more days so I can get this paid.
All right. So what are you asking for, Mr. Boyce, as it relates to Mr. Robinson's matter?
The same thing, just the $15.23 process serving mileage fee.
How much did the process server charge you to actually serve?
Well, we have an agreement where with our well, $50 each.
Yeah, that's it. I'm not going to give you the mileage on this case. So you want what you this gentleman says that he needs time to pay it or something. Mr. Robinson, what are you asking me to do as it relates to time to pay?
Yeah, if I could get time, I understand I do owe the debt. I'm acknowledging that. I just need time to pay. I got our initial court date. I had a date, but I got hit with the IRS garnishment. So I'm trying to take care of that. But within about 35 days, I'll have that paid to the company.
All right, Mr. Boyce.
Yes, Your Honor.
Yeah, he says, I think he says he needs about 35 days or so. And, you could do a partial payment agreement, but he seems like this gentleman is asking that he be allowed 35 days to pay this off without execution.
Well, we already have the judge. He can always call the office whenever he's ready to make a payment.
Okay.
All right, that makes sense to you, Mr. Robinson?
Understandable.
All right, very well. So I have granted the motion to consolidate these issues for the issue that was raised. And on that issue, at least at this time, I'm making a decision that I'm not going to award the request for the fees as it relates to mileage. You may want to reconstruct that as you go forward in terms of litigating these kinds of matters. I consolidated it. The motion is denied with respect to adding the mileage fees in each and every one of these matters. And that should close out the matter at this time. I do wish both of you well. Happy holidays to you.
Des, can I get his P number?
There is no P number here. Mr. Boyce, you're not a lawyer, correct?
I'm not a lawyer, no.
Oh, okay.
Okay. All right, the court now calls case number 17-117522. This is ABC Auto Finance versus Prozina, the Beast Purifoy. There was a motion to set aside an installment order. The court did take that motion under advisement, set the matter on or hearing on today's date. I wanted to review this matter on the petition to set it aside. Looks like the court issued an order on the 16th of March, 2022 for $175 per month. Subsequent to that time, there was a petition to set that aside. Your appearance for the plaintiff ABC Auto, please.
Good morning, Your Honor. Robert Zielinski on behalf of plaintiff P69250.
Thank you, Mr. Zielinski. Good morning to you, sir. I'm looking now for Ms. Purifoy. If you on the Zoom, say something to me, ma'am.
Hi, I'm here.
All right, and good morning to you as well, Ms. Purifoy. All right, so tell me about the setting aside of the installment. It looks like when I read this, it did indicate that there was a lot where the defendant had fallen behind, but obviously if she's not paying, then I would have to set it aside. Tell me what's going on, Mr. Zielinski.
Sure, Your Honor. We did have a chance to talk in a breakout room. And she just doesn't have any money to pay right now. She was working back around when this formed, and now she is basically a full-time student and working so small in hours that I don't think there could be a garnishment or a payment plan. So as far as I understand from talking to her, there's no chance for an amended plan or any kind of payment. So that's plaintiff at this point is just seeking to have it set aside and go from there.
Got it. Ms. Purifoy, is that about the size of thing? The size of things that you want to tell me?
No, other than working full time. I'm sorry, I'm going to school full time right now, so I'm only working 3 days in a 6-week period. So I really don't have anything for them to garnish for real.
All right. Having listened to the things that you all communicated to me, I will grant the petition to set aside the installment order. Obviously, you haven't paid, and there are good reasons to demonstrate that you will not likely be able to keep up with the installment order. Obviously, the defendant, strike that the plaintiff is left to whatever approaches they may find to try and collect on this, but I'll set the installment order aside at this time. Both sides will receive a copy of that order in the mail in the next few days. We wish you well. Thank you.
Okay, have a good day, Judge.
The court now calls case number 22-179657. This is Munich Insurance Company versus Marathon Garnishee, defendant Best Buy Services. All right, your appearance for plaintiff Munich, please.
Yeah, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff P59146.
Thank you, Mr. Cox. Good morning to you, sir. For the I believe the Garnishee defendant, go ahead and give me your appearance at this time.
Good morning, Judge David Burkle on behalf of the defendant. It's not a garnishment, Judge. P number 39098. This is a bad gas case. We were before you some time ago, and there was a dispute regarding the receipt provided for the gas purchased by the plaintiff's insured. That issue still exists. So.
Thank you for the update, Mr. Burko. And I do recall that I sent this matter over for review on today's date. So in the great wisdom of the two of you putting your heads together, you have come very forward.
We haven't been able to work it out yet with both of our brain pans combined. So
Yeah, Judge, I think counsel's correct. I think we need to kind of push ahead on this a bit. I guess we briefly discussed it 30 seconds before calling our matter, just to maybe get a scheduling order as we continue to work on overcoming the issues.
Yeah, I see. I didn't issue a scheduling order, and I guess there was some thought that maybe you'd be able to drill down on that sort of primary issue.
Yeah, I think Brother Counsel was optimistic that we might otherwise resolve it, but alas, we're still here.
All right, so I will go ahead now and set up a scheduling order on this. And what I'm going to do is I'm going to give you a return date. That return date is going to be the 23rd of January, 23. And I will allow discovery through that date, and I'll set that date as a pre-trial conference. In my scheduling order, we'll also have a paragraph number 6, which allows you to file motions, dispositive or otherwise, and set the motion for hearing on that date, January 23rd. All you have to do is give the other side 10 days notice. I know that's shorter than what's allowed typically in the court rules. By court order, you can file a motion, set it for hearing, as long as you give the other side 10 days notice before the hearing date. I will hear the motion on the 23rd. That does not preclude you from filing motions in the future. It's not a cutoff date for motion filing. It's just if along the way you discover that this case could be resolved in some way by way of a filing a motion, you can do so without delaying set on that same trial conference date. All right, so you'll get such an order from me. Your next action date is at 9:30 a.m. on 1/23/23. We'll get a scheduling order with that date as well as the other information regarding discovery as well as motions and etc. I do wish you well, gentlemen. Good day to you and happy holidays.
thank you, Judge. Happy Thanksgiving.
Happy Thanksgiving, Judge. Have a good day.
Bye-bye.
This is case number 22-189-625. This is BYOD LLC versus last name is Chowdhury. Amir Chowdhury, I believe. The matter is before court settlement for a pretrial conference. Looks like I did receive the answer to this matter on or about the 7th of July. I don't see where there's a schedule. Your appearance for PYOD, please.
Good morning, Your Honor. Navjot Francis, P72322 on behalf of Plaintiff's Attorney of Record.
All right, thank you, Ms. Francis, and good morning to you, ma'am. I'm looking now for last name Chowdhury. Give me your name, sir, if you're here.
You're muted.
Yeah, take yourself off of mute, sir, and say something, Mr. Chowdhury. Yeah, you're on mute, so hit your unmute button if you will. You hit *6, that'll get you off. Or if you have a microphone device, that'll get you off of mute. You're on mute and I can't hear you.
Okay, Your Honor, good morning.
Judge, good morning. I'm the interpreter for Mr. Chowdhury.
What are you doing? All right, are you represented by counsel, Mr. Chowdhury?
No, he's the interpreter.
Judge, I'm the interpreter.
Okay, got you. All right, so what pronounce your name for me, please, sir.
Judge, asking me? Yes, Judge. I'm Syed Zaman, SYED, last name ZAMAN. I'm the court interpreter for Mr. Chowdhury.
All right, and what language are you interpreting, sir?
Judge, Bangla. Bless you. Bangla. Bangla, Judge.
All right, raise your right hand and be sworn at this time, sir. You do solemnly swear or affirm that you will interpret the truth from Spanish, strike that from Bangla to English.
English.
To Bangla to the best of your ability, so help you God.
Yes, I do, Your Honor.
All right, thank you, sir. Good day.
You're
to
welcome.
you. All right, Madam Counsel, update me on what's going on here, if you will.
Judge, we adjourned this last time to send Mr. Chaudhry a fraud affidavit. He stated that he was out of town and just received it when he got back this week. And so we're just asking for another adjournment. He said he would have it to us by the end of this week.
By Judge Education, Ukil Tan Kushe, Afne Pucha out of town. Afne Khali Unuka, Arapta Tarik di Ballagi. Afne Satar Bitre Taralaga Jugaju Korba.
Yeah.
Yes.
Auto system.
So you need some additional time to get the fraud affidavit filled out. Is that what's going on here, Mr. Chaudhry?
Afne Aro Somersa affidavit form ta fill up for Tata Shetoni Judge Jigira.
Oh, Shotto.
Yes, that's true.
How much time are we talking about? Can we do this by December the 22nd, or do you need more time than that?
I think that would be perfect, Judge. He said he would have it to us he would get it done by the end of this week. So if we get it by next week, it would give us some time to review it.
All right, so I'm going to go ahead and set it up for next year. I'll go ahead and set that for the 20th of December, 12/20.
12/20, yeah.
20 is a Tuesday, Judge.
Yes.
What time, Judge? I have Frank Murphy, at 10:30 on the front of Judge Knapp.
All right. So we'll set that at 9:30 a.m.
10:30, I'm scheduled on the front of Judge Knapp for a review. Frank Murphy.
Good. So if you're here at 9:30, you should be able to make that one, right?
Okay, Judge. So 9:30, Chaudhry Bhai, 9:30, Shogal Shayanota Shumo, December 20 tarik, which is a Tuesday, Mongolbar.
You're fun.
Yes, I can do it.
Okay. All right,
Thank you, Judge.
12/20/22 at 9:30 a.m. I'll review the matter at that time.
Yes, Judge.
Thank you.
Again, Judge, December 20.
Yes.
Yes, by December 20 tarik, Shogal Shayanota Shumo, okay? Okay. Judge, am I good to go, Judge?
You're good to go, Mr. Chaudhry.
Thank you, sir. Appreciate it. Thank you. You have a happy Thanksgiving, Judge, and all the court staff.
Ready? All right, this
Thank
is
you,
case
Anna.
number 2218990. This is Angela Brown versus April Hare. The matter is before the court on the following of a complaint alleging.
Say something. Yes, I'm Angela Brown.
All right, so do I have Angela Brown on the Zoom?
Come on, come on, say again. That's this is Angela Brown.
All right, good morning to you, Ms. Brown. All right, do I have April Hare on this Zoom?
Yeah.
Say something. You hear, Ms. Hare? I see somebody with that indication. You have to unmute yourself, Ms. Hare. *6 or microphone. There you go. Good morning to you.
Yes, I'm here. Good morning. I'm here.
All right, what's your name, ma'am?
My name is April Hare.
All right, thank you, Ms. Hare. All right, so I see that you filed a response to this lawsuit. It looks like this is the first time that this is up, and I will likely set up a scheduling order regarding this matter. Tell me, it looks like just 1 second. Let me take a look here. right, so Ms. Brown, you're
Yeah.
saying that, yeah, you're saying that Ms. Hare hit you with an object and it caused you to actually lose, you became blind in your left eye?
Yes, I am blind in my left eye, and I do have to have it removed in 3 months.
So why did you file this in circuit court? Why did you file this in circuit court with higher jurisdictional amount to sue for such an injury? The most that could possibly be awarded here is $25,000. In circuit court, you could sue for something more than that.
Tell me that now. I didn't know.
Yeah, you probably need to have this. You probably need to have this case in circuit court, man. If you incurred an injury that's that serious, are you saying that if you won that you settling, you're waiving anything over $25,000?
My eyes way worth more than $25,000, and what she did is jail time. This is attempted murder. What she did to me.
All right. Well, you have to take that up with the prosecutor's office. But this, you're here suing civilly, trying to collect damages. Have you informed the police? Have you taken this to the prosecutor?
Yes, I went down to the police station and talked to the police station. They the one told me to put the civil lawsuit out.
Okay. All right. And ma'am, have you talked with a lawyer to get them to represent you on this at all?
No, you haven't. No.
Yeah, it's like I don't know. I don't know the truthfulness of it here. But if what you're suing for is that you are permanently injured and blinded in one eye, that you need to take that to a different court here. I mean, the best or the most that I could award, if I find in your favor, is $25,000. So
well,
here's what I want to do. I think that you need to. So I'll give you some time to do it. I'm gonna give you a date to come back, but in between now and then, you probably need to talk with a lawyer and tell them that you want to sue somebody that calls you blindness.
yes, okay.
All right, and I'll review it. I'll review it on the next date that I can give you. In fact, that'll be the December the 19th, 12/19, 22 at 9:30 a.m. Both of you be back here at that time, but you should get someone else, see if you can get someone to help you to go forward with this, to sue regarding this matter. And if you can't, then you still likely need to take this to the circuit court, because I know that you're suing more than $25 high.
Yeah, because my doctor bill is way over $20,000.
Yeah, all right, you're gonna need to, so see if you can get a lawyer involved. And if you can't, either way, come back, both of you, Ms. Hare and yourself, back on the 19th of December at 9:30 a.m. and I'll take another look at this to see which way it should go.
Yeah.
All right, good day.
Come on, John. Your Honor, can I get a pencil, please, to write this down? You say December the 19th? December. Oh my God. Excuse me, Your Honor. I'm trying to get a pencil because I got glaucoma in my right eye too, so my eye's kind of blurry.
All right. We're gonna send you a notice in the mail as well, ma'am. But December the 19th, December the 19th at 9:30 is when you need to be back. And that's also with you, Ms. Hare. December the 19th, 9:30 a.m.
Okay, thank you.
All right, I wish you to well.
All right.
Okay.
December the 19th. You got your thing through the mail. I know.
All right, this is case number 202619, Palisade Collections LLC versus Natasha Johnson. The matter is set before the court for review on today's date. This is regarding objections to a writ of garnishment. Your appearance for the plaintiff.
I'm here.
For Palisade Collections, your appearance, please. Yeah, you're on mute, Mr. Bader. So take yourself off mute, sir. So, Mr. Bader, you may need to hit *6 or something, sir, because I can't hear you. You're on mute. Ms. Johnson, I heard you. I see that you're there, Ms. Johnson. Good morning to you.
Good morning.
Mr. Bader, are you technologically challenged? Oh, there you are.
I guess I am this morning, Your Honor.
Your appearance at this time, sir.
David Bader, P67307.
All right, thank you, sir. Go ahead and update me. I remember we had some discussions regarding this writ of garnishment, and there was some effort to get this resolved in some way. Somebody, well, go ahead, Mr. Bader, if you can update me, sir.
Sure. It looked like you were recommending us to settle for around $8,000. She was going to pay $5,000. We were going to get the remainder from the garnishment, which equaled right around $8,000. However, we got the answer from the employer, and it says she's either part-time / contract or have a higher priority in place. She's stating there's no other garnishment there, so we just received this. We're not sure why they didn't send the money to us unless because of this hold on it. But she's willing to pay the $8,000 to us by the end of the year to resolve the case.
Ms. Johnson, there is what's being said here is that there's a bit of an issue regarding the money being turned over to the plaintiff. But they're willing to go forward with the agreement to pay this off at a total amount of $8,000. So that's down from the overall amount that's owed. Is that acceptable to you?
Yes, and the hold from the garnishment was because we turned in the paperwork for this hearing. So until this was completed, that's why they haven't released the funds.
All right. Now you understand that if for some reason they don't release the funds to the plaintiff, that you would owe the difference between the payment that you're going to make, the $5,000 payment, and what should have been taken as a garnishment. In other words, if it's $8,000, it's still $8,000 to get it resolved. You understand?
Yes.
All right. So what I will do then is I'll sign an order releasing the funds to the plaintiff, the funds that are being held by National Realty Center, and then you're going to take care of the balance of. I believe that the agreement is in December, Ms. Johnson.
Yeah, by December 31st.
Yes.
All right. All right. So I will sign an order with that language in it. That order will be on the objections to the writ of garnishment. It will release the funds withheld to the plaintiff. And then it will also say that an additional amount of $5,000 will be paid by the 31st of December, and that would conclude the case. The document will indicate that the total amount that the parties have agreed to resolve the matter is in the sum of $8,000. That acceptable? Is that acceptable to you, Mr. Bader?
Yes, $8,000 of new money. That's correct, Your Honor.
That's acceptable to you, Ms. Johnson?
Yes.
All right. I'll sign that order with that particular language, and I'll get it out to you right away.
Thank you.
Very good. Thank you, Judge. Thank you both. Bye-bye.
Bye-bye. Good morning. My name is Shauna Dorsey, and I was scheduled for
I'll be right with you. I'll be
9:45.
right with you. I'll be right with
Okay,
you.
all right, thank you.
This is case number 17-105-077. This is Department Store National Bank versus Shana Dorsey. The matter is before the court on the petition for reinstatement of a consent judgment. Your appearance at this time for the plaintiff, Department Store National Bank. Counsel for the Department Stores National Bank, please. If you're on the Zoom, please say something. All right, Ms. Shana Dorsey, I believe that you're on the Zoom. Say something at this time.
Yes, I am.
All right, this is a petition by the plaintiff to reinstate a consent judgment. Looks like there was a consent judgment that the parties agreed to. And it looks like that. I'm looking for a date on that document. Looks like it was entered sometime in 2017.
It was entered 2017. They didn't contact me until 2021. I had a court date set in July 5th of 2022, where you dismissed it. I forwarded them the information that was sent to me by the courts, and they did not accept it. And that's why they put in the petition.
I never dismissed this case. What you're referring to is I granted an order to satisfy the consent judgment. And I granted that on July 5th of 2022. They have filed a petition to reinstate that, indicating that the balance of that judgment has not been satisfied. That's what they're saying. So I see that when I issued the order, it said that you had paid $1,750 as a settlement of the judgment. So when you paid the $1,750, how did you do that? Was that a check or what was that you paid?
It was by check, and I went to my bank and got copies of the transactions and forwarded to them.
All right, so you received a copy of the motion in this matter, is that correct, ma'am?
Yes.
So they're saying that they never received any money from you.
The company, the department store, which is Macy's had at the time, is no longer in business, from what I understand. But the new company whoever took over the account has not produced anything but just this when I already been to court regarding this, and it was a settlement that should have been put in on behalf of this company, that it wasn't done.
So did you pay, the question is, here's what they're indicating is that they have not received any payments since that judgment was in this case.
That's not true.
I'm sorry?
That's not true. The account, as far as I knew, was considered satisfactory August or September, I think, of 2017, 2015. So whenever I went to court, they gave me like 3-4 months to pay it off, which I did, but I never got the letter to state that it was satisfied. That's what it was.
And you have records of your payments?
I do. I have my bank statements.
All right, so what you need to do, ma'am, is you need to send those items to me. So I can take a look at what you you're indicating, because the motion that they're asking you to set that satisfaction aside is indicating that they've never received any payments. But you already read it, you know that that's what the plan is. So you're gonna have to present something to show that you have in fact paid this. So why don't you email stuff to the court before, correct, ma'am?
I've never, but I'm sure I can figure it out.
Yeah, well, that's what I need you to do. And,
Okay.
Direct it to Judge Coleman's courtroom. That's me, Donald Coleman. There are 2 Colemans here, so that will be sure to put Donald Coleman. And it will get to me, and I will review what you have by way of proof of payment in this matter. And then I'll make a decision as to whether or not the satisfaction should be set aside. Obviously, if you pay, then that should resolve the case. If there's no evidence of payment, then that would not resolve the case. So we have to go from there. Okay. So what I'm going to do is I'm going to set another date. Go ahead and set that date for the 21st, December 21st, 2022. And I can set this at 9:45 p.m. December 21st, 2022 at 9:45 p.m. And I'll take a look at it at that time. Make sure you get your documents, proof of payment for that date.
Okay. Can I get it off of the website, 36 District Court, the email address, or do you have it for me?
Yes, ma'am. I mean, that's where you want to get it. But I think, well, I said for 421 Madison. 421 Madison. And directed to clerk to Judge Donald Cole. Clerk to Judge Donald Cole.
Okay.
All right.
Okay. Got it.
We'll take a look at it at that time. We'll get a notice on the mail.
Okay. Thank you.
Again, I'm calling the subject 6825. That's LBNB funding versus Gail Thomas. I called this matter previously. Looks like there is a motion for summary disposition for the court. I do see that Ms. Thomas is there. I thought I saw counsel on this matter as well. Madam Reporter, did I see the attorney on this matter was in Zoom?
Miss Francis, Norwalk Francis, is that what you're talking about? Because she was here. I thought this would be her case, but she had that other case with the interpreter. Miss Francis. She usually does LBNB.
Okay. All right, Ms. Thomas, are you able to come off of Zoom this time? Are you off of mute, Ms. Thomas? Thomas, if you're able to hit *6 and come off of mute, you can speak to me at this time. Gail Thomas.
I think she's asleep. Oh, there she is.
Okay,
All right, good morning, Ms. Thomas.
yes.
Yeah, you gotta speak up. I can hardly hear you. Good morning to you.
Good morning to you too.
All right. I see that the court did enter a judgment in this matter on the 25th of October for $1,740. That judgment was granted by way of a motion for summary disposition. The court could not find a genuine material issue of dispute, and that's why that judgment was entered. You filed a motion. You said that I want to be in a meeting. I do not want to pay what they, or I do want to pay what they want to pay. So what are you trying to tell me now?
I was in the hospital at the time
I
that
can't
I
hear
owed
you.
them. I told them I was in the hospital. I had surgery, heart surgery. And then after that, I was in the hospital again. I had 2 heart attacks because the heart wasn't closed. And after that, I had 2 strokes.
Wow.
So I'm not working.
You're not what, ma'am?
I'm not working. I'm through working. I'm on Medicare and Medicaid.
Well, what that means, Ms. Thomas, is that means that they can't really do anything with the judgment. I mean, if you owe this money, the next step is for them to try to collect it. But if you're not working there, you don't have any source of income there. They don't have any way of collecting it. If you get to the place where you're in a position to begin paying this off, then what you likely want to do is file a petition to ask for partial payments. But that's only when you get in a position where maybe you have some money where you could pay something. If you don't have anything to pay and you don't have a source of income, there's nothing that they can do to collect it. You understand?
But there's nothing they can do to collect it because I always pay my bills. But because of all of this, no, I can't pay it. I just get Medicaid and Medicare.
I understand, ma'am. They do have a judgment against you, but if you don't have any money and you don't work or have any source of income, there's nothing that they can do to collect on that judgment. Again, if you ever get in a position where you got a job or you're going back to work or anything, then you'll want to contact the court and file a petition to ask to make partial monthly payments so that they won't garnish your wages. But if you're not working, they can't garnish your wages.
No, I'm not working.
Okay. So I don't see, I noticed that you said I do want to pay, but you're just not in a position to pay. So.
Right.
So we'll just leave the case where it is. I don't have a reason to set the motion aside or to set the judgment aside. But I think the issue that you're raising is that you don't have any money for them to come after. So if you don't, you just don't. There's nothing that they can do. They have a judgment that they can't collect. All right, ma'am?
Okay. All right.
So the judgment remains in place. I do wish you well. Like I said, if you ever get in a position where you could pay something, then just file a petition and say, Judge, I'd like to pay whatever, $50 a month, $100 a month, or whatever. But if you're not there, you don't stress about it because they can't collect it. All right. Good day to you, ma'am.
Good day to you too. Hello?
All right. We're all set, ma'am. Good day to you. You can hang up now.
Okay, thank you.
And regarding the suffix 2820, HS Financial Group versus Tamisha Jones, the subpoena will be dismissed for not a party appeal. All right, yeah. Believe it or not, I gotta go read the past.
All right, you're still live.